Good morning, ladies and gentlemen. We'd like to welcome you to the seminar today, What Every Landlord Should Know. And we are a problem-solving court. My name is Ray Pianca. I'm judge of the Cleveland Municipal Court Housing Division, which is a specialized court that focuses in on the issues of housing, building, safety, fire, zoning, and environmental codes in the city of Cleveland and the village of Bracknell. The business of the court is to be a problem-solving therapeutic court, and that's why we're giving this seminar this morning. And we have information that hopefully will be valuable to you, and also are available to answer your questions about the process of being a landlord in the city of Cleveland and the village of Bracknell. I've been on the bench 15 years. I'm in the middle of my third term. Terms are 6 years, and I've been responsible for approximately 175,000 eviction filings in that period of time, and over 65,000 criminal cases that have also been filed against property owners or against tenants for alleged code violations in the city of Cleveland. Today we have an expert panel made up of court staff who have handled many of the cases that I ultimately have to sign. As you can imagine, with the volume of cases, we need to have professionals working, and of course I'm not alone in the housing court, but there are a number of people, key people, who work to process the important work of landlord and tenant matters. We have Magistrate Reuben Pope, who is here, who many of you have seen as you may have filed evictions or talked through pre-trials. We have Magistrate David Roberts, who you may have seen on evictions, but also key in working on a number of criminal cases. Mr. Pope brings a wealth of experience to the court, has been a magistrate for many years, but in addition was in private practice prior to his elevation, let's say, to the bench as a magistrate. David Roberts also was in a private practice, but also was a prosecutor for the City of Cleveland Law Department and has a special expertise in criminal matters. We also have some other experts that are here. Atoy Keela Hodge, who is back. Please stand up, Keela, who is a housing court specialist, along with Kathy Rosner. And housing court specialists are what makes the Cleveland Housing Court unique. Both of them spend their days helping people get out of trouble that they got themselves into in landlord-tenant matters. They also work on the criminal cases that are brought to the court, trying to find a solution to the many problems that we see as we experience the real estate crisis that we're in, not only in Cleveland, Ohio, but the real estate crisis that has permeated our entire country. Now, in the back of the room, we have our chief magistrate responsible for the magistrates in the court, the attorneys, and that's Barbara Reitzloff. We have also our staff attorney here, who is Sheila Wright, who works on many of the complicated legal issues that we see before the court. And then if you email the court, you'll reach my judicial assistant, Deanna Rodriguez-Moore, who is the one who screens the emails to make sure that nothing's inappropriate, because as you know, I cannot hear anything about a case before the case unfolds in the courtroom. So this business of being a landlord increasingly difficult, and in fact it's difficult in a number of ways. It's difficult because of the economic times. A vast majority, in excess of 95% of our evictions. What is the cause for those evictions? Non-payment of rent. So if people do not pay their rent, then we many times see eviction actions filed. In order to try to work out the relations between landlords and tenants, and unfortunately We see landlords from hell and tenants from hell in housing court, many times not matched up. We've seen horrible things that have happened to tenants and horrible things that have happened to landlords. And we've established a mediation program, and in fact this year have worked to increase the number of mediations to try to work out the relationship between landlords and tenants. Our goal is to keep you out of housing court, to keep you from being brought into the criminal side of the court, to keep you from having to file an eviction. And that's why we provide this information today. Now, I handle the criminal docket on Tuesday, Wednesday, and Thursday mornings, and I've seen some of you in that criminal court, and the fines can be quite costly. And if the fines aren't costly, the time at the jail can ruin your day. And the codified ordinances, as Mr. Roberts will outline, have specific fines that have been set. And if you are a corporation, you cannot be arrested, but the fines that you can suffer are enhanced from $5,000 a day for each day out of compliance, or even for a minor misdemeanor ticket, the waiver amount is $500, maximum fine $1,000. For a waiver for an individual, it's $95. Now, on the criminal side of the court doesn't go out and get the cases and brings them in. The city administrations bring them into court, and I just was informed this week that they have 400 cases that they want to bring before the end of the year concerning trash that's been put out too early, trash that hasn't been put out at all, or trash cans that have not been brought back in. And many times, landlords are vulnerable to these tickets based upon the fact that their tenants are not managing the trash in the proper way. And so we have a number of publications up on our website, and we've included them in your packets today. You might want to look at that one, Talking Trash. And if you have tenants, make sure they know what the rules are, and I'm sure you may have some questions about that. So without going any further as far as an introduction, I'd like to introduce Magistrate David Roberts, and he is going to tell you what every landlord should know concerning criminal code issues.
All right. Good morning, ladies and gentlemen. Good morning. Once again, my name is David Roberts, and we're going to talk today about what every landlord should know, and I'm going to do the criminal part, and then my colleague, Mr. Pope, is going to do the civil part. The criminal law is really something that you hope you don't need to know about. Ideally, it doesn't ever come into your role as landlord. Everything runs smoothly for you, but it's what you want to know about in case it happens. And then as a theme for today, I want to urge you to consider that even if you do your best and you are careful, the criminal law may still come into your practice as a landlord because you can't control everything. And so our first slide is about how the City of Cleveland will note if it continues to have a series of nuisances at a particular property. And as landlord, this may be because of what your tenants are doing or your tenants' guests are doing. But the city doesn't allow you to simply say, well, too bad my tenants are misbehaving. Let the police handle my tenants. If it continues to happen at the same property, they will begin to charge you for the cost to the city of responding to the problems at the property. And so one of the things you may want to do in response is evict your tenants, or at least see if you can talk to your tenants and get them to stop. And the police will note that this often, all these things happen together at one property. When people begin to flout the law, they flout it in various ways. And they'll send you a letter, and they'll bill you, and then they could bring a second-degree misdemeanor charge against you. These do not come in front of Judge Pianka necessarily. They could come in front of another judge. So if you get the letter or any contact from the police concerned about behavior at your property, make sure you understand that's part of your responsibility even if it's not your fault because it's your tenant making the bad choices. Here are some other things that you may not be aware of are obligations for you. If you have a rental property in Cleveland, you need to do a certificate of rental registration. If you have more than 4 units, you can't leave your tenants to do their own trash. That might suit them, it might suit you, but you can't. You have to have provide the containers, a place where the containers are kept, and monitor that to make sure the trash is being done right. If you have a custodian or agent at the property, some landlords sometimes don't understand that they have to do that in certain circumstances. They think it's okay if they just leave their name for the tenant. Sometimes you have to have an on-site custodian. And then identification of dwelling units, you wouldn't think that would need to be something people are urged, but you will find people who buy property and they don't label the apartments with numbers. They don't indicate the street address on the door. And so this is a problem for the city if it's responding for 911 or fire. And it's a problem for you if you bring an eviction, because now it's going to be harder to identify. So it's actually a legal requirement to put some kind of indication of the number on the door. As you can see, Judge Pinock has a very busy court. There was a dip in filings down to about 2006, but there are a large number of filings in court, ranging from the very minor issues like putting trash cans out too early, up to large industrial buildings that are in complete risk of fire with the landlord not taking any care. The important thing to know about the building code, housing code, fire code, and health code, you're probably aware that those exist and they set standards for property. What you should not leave here today without realizing is that the owner is required to keep the property up to those codes. And you could get a notice at any time from a city inspecting your property, and the notice will order you to make repairs. And you need to have some plan ahead of time for what you would do if that were to happen. These are the different codes. The most common would be housing code. There are more housing inspectors than building inspectors. As a landlord, you own probably most of you are residential landlords, not commercial, so the housing code would be most likely, but you might get a health code or building code or fire prevention code. Keep in mind, owner is a term that the judge has suggested in some of his opinions to the city might better be termed responsible party. We know that most properties, it's the owner who's in control of it, and the owner we look to be responsible. But occasionally you're in charge of property without being its owner. You might be leasing it long term, but you're in control of it. You might be various things like a trustee or a receiver, someone else who can say, well, I'm not really an owner. The city code says, well, we're calling you an owner, even though you're not really an owner. So eventually they may change that to responsible party. But you should keep in mind, whenever you have the responsibility, you're the one who would have to make the repairs. Now, here is a copy of a violation notice. Now, this is what you'll get if you ever get visited by a building or housing inspector. The health notices look similar. The fire notices look similar. And there's a protection for you here, which is that you get told what the inspection revealed. I don't know if you can see it in your materials, but they'll list each thing. And some inspectors are incredibly detailed, and they'll tell you every last thing. Sometimes they're more general, like the structure needs painting. They won't necessarily tell you where, but if you look, you could probably see where the paint is peeling. And then, as I say, this is a protection for you for due process. This tells you what the city's saying, and you are entitled to disagree if they bring you a notice and they say, and particularly they'll tell you how long you have to repair it, and it's almost always 30 days. And so if you don't think it's reasonable, given what the inspectors discovered, to fix it in 30 days, you can appeal that. If you don't agree with what the inspector says is defective, you can appeal that. Appeals are at City Hall, and you would have to do the work of going down and filing it. You have to pay a fee for it. But that would be a protection for you if you're looking at a situation where you're not going to be able to repair in 30 days. You can ask for more time. Or if you don't feel something on the notice is fair, you can appeal that, say, I don't think that this is defective. I should be allowed to leave it like it is. I won't go through all the detail of that, but just keep in mind, without an appeal, that piece of paper you got is like a formal order of your government for what you have to do. And people often later want to challenge it. They'll be brought to court. City prosecutor will tell you, it was an order issued to you, you didn't appeal it. So now you have to obey it. And just to leave in your mind a vivid, strict example of this, in Shaker Heights, I once talked to the judge at the Shaker Heights court. If you have mortar missing from your bricks and you fill in the mortar, the color has to match. So if you have pink mortar, you can't fix it with white because it'll look shabby to the inspectors in Shaker Heights, Ohio. And if you come to before her in court, I asked her, could a defendant in front of you then say, well, I repaired it, even if the color doesn't match? And she said, nope, they missed their chance to appeal. I apply the law as it is. And so they have to make the color match. You'd have to redo it, make the color match. I've not known a city Cleveland inspector to do that. This is a copy of a building and housing complaint. This is what the city will file against you if you fail to comply with a notice and they reinspect. And then it tells you that you're being charged under number 1 with failing to comply with a notice. The notice will be attached to it. So that's a pretty clearly understandable charge. We sent you this order, you didn't comply with it. And it could be you started to comply, but you didn't finish. There are no automatic extensions. Often landlords feel if they start the work, that'll entitle them to an inspection, an extension of time. You can ask the city to wait to prosecute you, but they don't have to wait. And this would bring you in front of Judge Pianka. You'd be facing some pretty serious penalties when your city council members pass these codes. They have to imagine the range of problems. This could be an absolute fire trap building. People are at risk of dying. So the penalty includes jail. You'll send that landlord to jail. Or $1,000 a day. Now the problem is then the failure to comply with a notice carries that penalty. What if all that happened for you was you had a gutter that was hanging, inspector visited, said you got to reattach the gutter, and you don't do it, and he charges you? Well, under the law then that's the maximum penalty. So then what you have to have, hopefully, is an excellent judge like Ray Pianka who understands that and is not going to order any jail time for anybody in that circumstance. He will match the sentence to the degree of responsibility. And particularly organizations, because they can't go to jail, have enhanced penalties. And recently Judge Pianka has been increasing the fines on banks and speculators in property who buy large numbers of the worst abandoned properties and do nothing with them. And the $5,000 enhancement and the fact that you can get a fine for every day when you fail to comply lets the judge have leverage on those corporations. On the lower end of the scale, the minor misdemeanor tickets, they look similar, but if you read one through, it'll let you know you're allowed to send in a payment. So we've probably all been convicted of something like this, which is traffic tickets. A policeman pulls you over for speeding, that's a minor misdemeanor ticket. It's similar. You can come to court if you want to contest it, or you can mail in a fine. So the health inspectors, housing inspectors, building inspectors may give you a minor misdemeanor ticket. And then you could decide to just pay it if you don't want to come in front of the judge to contest it. Here are the most common ones. And I'll return to my theme. If you're a landlord, what does it mean for the trash to be out too early? Well, it's probably going to mean your tenant did it. Your tenant's leaving town and doesn't want to wait and have some friend take the trash out. So they put the trash out a couple days early, so it won't be where they are. As the sanitation guys go through the city and pick up the trash, they have one assigned to go to the streets where it's not trash day and look. And if there's cans out, they'll go and find that address. Now, who did it? The tenant did it, probably. But they don't know who your tenant is, so they're going to send you the ticket. And so you want to make sure your tenants don't get you into this trouble. So explain to them about the requirement to take the cans, not to put the cans out too early. It's 12 noon the day before trash day, which is a long time. To me, it's a long time. That gives you from noon till midnight if you want to do it before rushing in the morning, or you could do it in the morning. But if you're going out of town, you're not going to be able to do it. You've got to get someone else to take the cans out. Other common ones, junk cars. Junk for the city ordinance means that it's not licensed. It doesn't have a current tag. So it could be a nice car. We call it a junk car. But it could be a really nice car, but your tenant hasn't kept it registered. Or it could be registered, but there's something wrong with it. Flat tire, they'll give you a junk car ticket. Because if it has a current flat, it's not running. Or, as you can imagine, it could be terrible. It could be up on blocks and completely dismantled. And they are not allowed to have those for any amount of time. Your tenants may say, well, I had plans for that. I was working on it. I was going to fix it. There is no amount of time you're allowed to have a junk car. Debris, high grass and weeds also. 8 inches in height and for the grass and weeds. And debris that you didn't put there. This is back to our theme. If someone comes, your tenant might do it or someone else might do it, and they dump things on your property, you have the responsibility to remove that debris. And the judge is very sympathetic to the fact that you didn't put it there, but he will handle the case based on the fact that once it was there, you failed to remove it. So keep in mind, you've got to visit your property. A lot of times, landlords in front of Judge Pianka are there because they didn't visit. Disclosure cases, this'll, in your life as a landlord, there'll probably come a time when you sell your property. And so this is one to remember when you sell. When you sell, you got to go to the city and get a disclosure form that indicates if there's any current violations and other information as well. And then you give that to your buyer so that no one is selling a property that's in the midst of being prosecuted or having a notice from the city without telling the buyer. Not fair to the buyer and doesn't cause the repairs to be made too. Even if the buyer knows the defects, they need to know that there's a deadline for fixing the defects. But ideally, if you become a successful landlord, buy more, you'll be on the other side of that. And selective intervention program, once again, as a landlord, this probably wouldn't apply to you. But if you do live in Cleveland and own your own house in Cleveland, you could take advantage of this program, which Judge Pianka designed when he took office, in recognition of the fact that criminal prosecution of homeowners may not be the best result as a way to make them fix defects in their property. That if they come forward and admit responsibility and make a plan for fixing defects, perhaps they should be forgiven. So the program costs $25. You make a commitment to repair, and if you complete your commitment, the case is dismissed. So there's no criminal record and there's no fine. It is a one-time program. So if you go through it, you're expected not to enter it again. If you once again let your property get defective, you may have to go in front of the judge in the regular way. When defendants ignore their responsibilities, hopefully this wouldn't apply to any of you because you're going to be conscious of your responsibilities, but this is more just for your information to let you know, because on the streets where you own property, I'm sure there's defective properties. And when you drive by, you think, who owns that one and why don't they fix it? The judge is doing everything he can to bring in everybody who is due in court. The clean hands doctrine says if you are particularly commonly a bank like Deutsche Bank and you own some hundreds of properties in Cleveland and you want to put out the tenants who don't pay or the tenants who you never reached agreements with, and you're also simultaneously wanted in front of Judge Pianka for criminal violations, if you don't show up on the criminal docket and at least go through with the case, he's not going to let you go forward with your eviction. Trials in absentia, for those interested in legal issues, is it possible to have a trial when the defendant won't come to court? There's a state statute that says there is a limited circumstance in which you can do it. When Judge Pianka's research found that, he was delighted because he thought, you know what, on these particular cases, I'm just going to go forward. I'm not going to wait for Deutsche Bank to come in. I'm just going to go to trial against them. Those were appealed to the Ohio Supreme Court, which made a narrow ruling saying that this court couldn't do it in those circumstances. So the basic idea of that is just the justification for holding up those evictions. And that could happen to you if you're wanted in criminal court and you don't know it. You might learn it when you come into 3A, the bailiff might tell you, your eviction can't go forward today. You have to go up to 13, and then you'll learn what the issue is. Hopefully this will not happen to you. This is the corporate docket. As I say, not really an issue for you, but worth knowing that the judge has made an effort to bring companies like this who own many, many properties. Bryce Peters buys huge numbers at a time. Other groups buy banks. They buy many at a time, and they won't even come in court. So he's fining them now for failing to come. I'm going to go back to this. Ohio Supreme Court said, can't try them without them there. Judge Bianca said, well, what can I do to them then? I need to make them appear. You could fine people for not coming to court, fine a corporation for not coming. So he's currently fining them $1,000 a day for not coming to court. And there's a check from J.P. Morgan Bank, because you can't not pay your court fines either. One of the things these companies will do, they're not going to volunteer to pay the fine. So they will get fined, but they'll figure, well, what the court's not going to catch up with me. The judge, through the clerk's office, hires attorneys, and they will find the defendant and find assets that the defendant has and take the assets away. So here's a house where J.P. Morgan was fined $53,000, and they were made to pay it. The judge is doing what he calls comprehensive sentencing and plea agreements. For someone who owns many houses and many of them are in disrepair, when the judge gets them convicted in front of him, rather than just looking at the property the inspector brought in to see if it gets repaired, because you can bet that landlord will focus on that property because it's in court. A judge says, I'm not going to focus only on that property. I want to look at everything you own, particularly the larger property owners. And so here are some examples. Christiana Bank was a bank that owned a bunch of properties that were vacant. They tore them all down, principally. Mr. Dionysopoulos is a landlord. He's constantly in court because we're monitoring all the properties he owns, not just the ones he was brought in on. So, and then if it would come to it, either for your information or if it would come to you coming to court, I want to explain again about the sentencing. We said that the judge will give a sentence appropriate to what the circumstances are. Not only will he do that, but he will make a sentence anticipating that he will forgive most of it. He'll suspend most of it if the landlord fixes what's broken. So many landlords are not fixing the defects in time. The city brings the case, and then if the landlord says, I'm going to admit that I'm guilty, they plead no contest to say, Judge Bianca, if I fix it later, will you suspend part of the fine? And that's his normal practice. So he'll continue it a number of times. Then when the city finally reports everything's finally done, he'll suspend as much of the sentence as he thinks is fair. And I think our next slide is, these are factors to consider. What makes it more serious or less serious? And here's the 90% mitigation. It's normally 90%. Now that's not in any law anywhere. That's just the judge's practice. So a landlord might get a $10,000 fine because they have a condemned garage and they shouldn't leave it there. And so they pay to demolish it. And then he would forgive 90% of that. Landlord pays $1,000. Why do they pay $1,000? Because they never should have let their garage come into that state. When ordered to repair it by the city, they should have repaired it or torn it down. They shouldn't have waited. They had to be brought before the judge to be forced to do it. So if he forgave the entire fine, there'd be no deterrent effect. People could just wait until they're brought to court. Now, I put a big beware there. If you ever do come to court, it's not a promise that you'll get 90% suspension. It's a normal practice. You could even get more, but it is not a promise. And then motions to mitigate are the same thing, only the judge does it on paper. If you were to have a case and enter a plea and be found guilty, a judge might order the sentence executed, but give you a chance to bring in a written motion and pictures explaining that it's repaired. That keeps you from having to come back to court. Beware, he doesn't have to grant them. Victim restitution is a new issue for Judge Bianca. One of the things that's part of the current housing crisis is that everyone on the block suffers from the people that don't make repairs. As I said, I imagine all of you on the streets where you own property see properties you wish were in better repair. And so the judge is considering whether, as part of his sentence, he would ever give restitution to the victims. So if you say, I live next to this derelict house, it's not been repaired. I can't sell it. I can't borrow against it. I have other issues. Make the defendant pay me some money to make me whole. Victim restitution is obvious in a case where there's an assault. If I attack somebody, then I can pay them their hospital bills. Or if I steal from you, I can return to you either the item or the money that was lost. This is a little more hard to prove because we need to look carefully at the result, but the judge is investigating that. Any questions? Sir?
It was for the lead paint.
Yes.
I got a property that really had the lead, and now the tenant is complaining that, the kids had, and they had not been there for a long time. So they came from somewhere else, but now I don't know if I had to, how that would work.
Lead paint is a risk to children because the lead comes off the paint. So the health department will order you to abate the nuisance of the lead paint, which usually means painting over it. So the thing to know is, no matter what is happening with that child, and whether they have a problem from the lead, whether they've been there a long time or not, you still have to abate the lead, and you have to do it through a special process. So this is one of the times when you've got to contact the inspector to find out what the process is. You have to use a lead abatement contractor, and the lead abatement contractor has to have somebody certify that it was done correctly. Now, your other question was, what about the tenant's claim against you? If the tenant brings a claim against you, you'll have to defend. No one can prevent them from bringing it. If you defend, if you have insurance, you should call your insurance company and they'll help defend you. Otherwise, you'd be defending yourself. At that point, you could raise as a defense that your tenant can't show that their child's lead poisoning is caused by your unit, because they did live other places, and so they may have already developed the lead poisoning. They would have to prevail on a claim against you for money to pay for the child's medical care. They would have to show that you caused it. And at that point, you'd be well suited to get an attorney to understand it, because it's complicated. All right, another question?
Yes. How often do the city of Cleveland do home inspections, housing inspections?
This is a great question. I was housing court prosecutor from 1992 to 1995. And one of the things that disturbed me was that the inspectors would go based on complaints. So that I would have defendants that I'm prosecuting in court who would show me pictures of properties on their street that were much worse than theirs. And I would have to tell them all, we're not looking at your neighbor's property. We're just looking at yours, and you have some defects, so we have to go forward. But I would think to myself, why doesn't the city inspect all those properties? And there was an effort to do that, and I understand inspectors are currently, after many years, on a two-part regime. They're sent places. So if a call comes in for your property, they'll be sent to your property. They're also encouraged and have authority to inspect anything bad on that street, but they're not required to. So you might still end up with that. So that's an administrative question for the mayor and his department head, Mr. Ribka. And the court has, I think, explicitly said this in written decisions of Judge Bianca, that a targeted approach would best serve Cleveland, so that you would walk right by a hanging gutter on one of your properties that needs to be repaired but isn't a priority, and then head for the vacant house at the corner. That's the real problem. Also, ideally, the code says they should visit once a year. They don't have enough staff to visit every property once a year, so they don't do that either. All right, if there are no more questions, we'll take a brief break, and then we'll begin with Magistrate Pope.